is Jacqueline Nolan-Haley, Professor of Law, Fordham University, Fordham University School of Law. Are you okay? And the paper is Ghana, The Way Forward with Justice, Blending Traditional and Modern Dispute Resolution. And so I hope on one hand we can eat, at the other on the other hand we can do some listening, okay? And so Professor Nolan-Haley, okay?
What an honorable task I have during the middle of lunch to talk to you about access to justice in Ghana, but let me try. It's a privilege to be here, especially among so many distinguished traditional leaders and scholars and practitioners of peacebuilding. I'm very much humbled. And the more I listen to what everyone has to say, the more humbled I become. What I plan to talk about today is based on my title. It's Access to Justice in Ghana, and a reform movement we call ADR, which most of you are so familiar with. The term ADR, as you know, refers to, well, we have many interpretations here in the US. We would say alternative dispute resolution, appropriate dispute resolution. Europeans might say amicable dispute resolution. Some people say African dispute resolution. Nonetheless, it's about alternatives to having a court resolve your dispute. And we know arbitration, mediation, negotiation. Ghana is one of several African countries where ADR processes have been promoted. And why is that? The idea was that it would improve the court system. And if we improve the court system in Ghana or in other African countries, we would encourage and facilitate foreign direct investment. Another idea behind ADR was to reduce judicial corruption and, of course, the old buzzword, to provide greater access to justice. The United Nations and several international organizations have exported ADR to Ghana with a great deal of enthusiasm, as many of you from Ghana know. They've trained many local chiefs in mediation and arbitration, and they have incorporated ADR programs, particularly mediation, into the court system. Implementing ADR in Ghana has been achieved through a process that some scholars will call hybridity. And we've heard a lot about hybridity yesterday from our keynote speaker and again this morning. So for example, Professor Richard Crook from the United Kingdom, who has done substantial research in Ghana, describes how the magistrate courts in Ghana blend customary law and common law with various kinds of informal and non-legal procedures. He also discusses the hybrid nature of Ghana's Commission on Human Rights and Administrative Justice. So this commission provides a form of dispute resolution that responds to local values and notions of justice. Even though there has been some success with the hybrid nature of ADR in Ghana, there have also been challenges. First of all, the manner in which ADR was introduced into the court system has caused problems with some of the chiefs. And it has resulted in resistance by litigants in some cases. So today I plan to talk about the development of modern ADR in Ghana, and I will consider how it both complements the traditional customary law system and how it acts in tension with customary law, and why that matters. At the end of the day, I will urge fidelity to customary law values. And this means that when ADR processes are integrated into the formal Ghanaian court system, we should still honor customary law, we should still respect the guardians of these values, and these are the chiefs, the queen mothers, and the elders. So first I plan to talk about Ghana's legal system, then I will talk about the development of modern ADR in Ghana, and then finally I will talk about achieving access to justice through traditional and modern dispute resolution in Ghana. So Ghana's legal system, beginning with that, has a pluralistic system of law. It draws from customary Ghanaian law and modern legal systems. Just by way of background, in 1876, English common law was introduced into Ghana. English common law brought with it all the trappings of the adversarial system. This included a focus on formal courts and the litigation process, the winner-loser mentality that we have with litigation. And so it disrupted traditional rule and governance. It disrupted indigenous dispute resolution. However, the colonial rulers did retain as much of customary law that they considered to be consistent with principles of, quote, natural justice, equity, and good conscience. Customary law is now recognized as part of the law of Ghana in its constitution in 1992. I think, however, it's important to remember that what we call ADR today has long been a part of Ghana's legal system. Before the common law was introduced, the traditional customary justice system focused on non-adversarial, amicable, and peaceful methods of settlement. And these methods included negotiation, arbitration, and mediation, the same processes used in modern ADR. These processes are conducted by chiefs, queen mothers, clan heads, family elders, and communal leaders. Chiefs continue to occupy positions of power today, and queen mothers have been included in the Council of Chiefs as part of a reform of the chieftaincy. But even though the traditional justice system continues to operate today in Ghana and coexists with the formal legal system, it faces several challenges. A report that was issued in 2013 on access to justice in Ghana identified a number of problems with traditional ADR processes, and these include cost, lack of fairness, cases that do not belong in the traditional processes, such as murder and rape, bias, difficulty of enforcing awards at the local level, and in sometimes negative attitudes by the judiciary and the bar towards traditional processes. Despite these problems, the report on access to justice concluded that traditional systems of justice are usually a better fit for local communities. And this is because they rely on inquisitorial and restorative methods of dispute resolution rather than the adversarial win-lose approach of litigation. So moving quickly now to modern ADR development, how this happened in Ghana. Ghana's court system experienced and is experiencing some of the many problems that affect other court systems throughout the world. The same sort of problems: inefficiencies, high costs, case backlog, inadequate resources, and sadly, corruption. All of these factors acted as an impetus to introduce ADR into Ghana. Under the leadership of our keynote speaker yesterday, Professor Ernest Uwazi, a program was developed in the United States to promote ADR in West Africa. This happened in the early 90s. 3 leaders in the legal profession of Ghana attended the program in the United States for 1 month. They returned to Ghana to spread the ADR message throughout the country. Just a note here, the former Chief Justice of Ghana has referred to Professor Uwazi as the father of ADR in Africa. So what a privilege to have him here yesterday. The official development of modern ADR in Ghana can be traced to the Courts Act of 1993, which encouraged the use of ADR in the courts. And we'll see a whole series of encouragement here. In 2001, the Lord Chief Justice established an ADR task force to make policy recommendations. 4 years later, he issued a policy directive to institutionalize ADR in the judicial system. The Ghanaian judiciary responded by setting out a 5-year strategic plan for ADR. And since 2005, the district courts have offered court-connected mediation programs. In the early years, there was popular support for mediation. Consider the language I will share with you of one African commentator who was a labor mediator and an arbitrator in Accra. And for him, the results of court mediation have been outstanding. And this is his quote. This is in the year 2009. "Families have been reunited. Marriages have been repaired. Children have been saved and their future secured. And landlords and their vulnerable tenants have patched up beautifully in unity, resolving to live in peace together." So high praises for mediation. In 2009 also, the Chief Justice established a National ADR Directorate to coordinate all ADR activities. All of these efforts culminated in 2010 in the passage of very significant legislation, I think, called the Alternative Dispute Resolution Act of 2010. This was comprehensive legislation that included a full range of ADR processes: customary arbitration, mediation, and negotiation for settlement. A very unique feature of this act was the attempt to integrate customary and modern dispute resolution. So we see in the act the intentional inclusion of customary arbitration and mediation in the formal legal system. Also, under the act, all settlement agreements reached through ADR would be enforceable. And finally, the act called for the establishment of ADR centers throughout Ghana. Public reaction to the act was mixed. For some people, passage of the act was an occasion that deserved to be celebrated. A leading ADR practitioner and president of the Ghanaian Bar Association, who now has just been put on the Supreme Court, says this, and this is his quote: "Indeed, a Daniel come to judgment, solving what was once the predicament of Ghanaians who had to resort to the expense, delay, and adversarial nature associated with a normal court process." The Chief Justice of Ghana also welcomed the new legislation. And there was much popular commentary claiming that ADR enhanced access to justice for persons who were unable to access it through the established court system. But of course, there were some negative reactions. Some stakeholders were skeptical about the ADR law. Some traditional chiefs were concerned with a loss of their authority and power under customary law. Some chiefs claimed they had been left out of the design process when the law was crafted. One particular critique by some chiefs is that they were not given the opportunity to participate in the development of a law which radically changed the position of customary arbitration. Ghana's Chief Justice responded to the chiefs' concerns as she tried to seek their support for the new law. She made it clear that customary arbitration still had an important role, and that it now stands, in her words, shoulder to shoulder with the other universally accepted mechanisms. She goes on, this is Judge Wood, "It has served our nation well and will continue to do so for a long time to come. This is why I would humbly appeal to our Nana to take advantage of opportunities that stand to broaden their knowledge and skills in ADR practice." So her words clearly encouraging the chiefs to get on the bandwagon here. So I've come to the question, has modern ADR provided greater access to justice? Has it met the claims? I've talked briefly about Ghana's legal system, the introduction of modern ADR into that system, and these are my questions now. So has it made any difference? Has it provided greater access to justice for the citizens of Ghana? Are they using court mediation to resolve their disputes? Interesting findings here. In general, settlement rates in mediation have been low. The Judicial Services of Ghana issues annual reports, and from those reports we see that the rate of settlement from ADR processes in Ghana dropped from 52% in 2012 to 43% in 2017, and the projection for 2018 is down to 30.5%. So you might wonder, why the low settlement rate? Well, in part, in some years there have been very few referrals to mediation because of structural problems. No space to conduct the mediation. Some people under trees doing mediation, or poor pay or no pay for mediators when the budget couldn't come through. But focusing actually on the low number of settlements, there have been several explanations. One scholar describes what he calls a well-entrenched culture of resistance to amicable settlement in Ghana. This seems to be particularly true in the case of land disputes, which have greatly increased with the rapid pace of urban development. Land has enormous value in West Africa. Studies show that litigants who file a lawsuit over land prefer going to trial and receiving a court judgment instead of a private settlement. But this attitude does not necessarily hold true with respect to contract or commercial cases. So why the discrepancy then between land and non-land cases when it comes to settlement, you may ask? Scholars have explained that land is considered a more fundamental, non-negotiable issue. It has symbolic value and increasing economic value, both in the growing urban areas and as security for retirement. But then how to explain the resistance to settlement apart from the land issues with the contract and commercial cases? First of all, I think this is an empirical question, and it demands much more research and funding to figure out what's going on here. But I have a couple of thoughts. I think one possible explanation is situations where mediation was introduced into a court system as a compulsory requirement. In my view, when mediation is no longer an informal process based on voluntariness, it can lose its attraction for litigants who are accustomed to consensual decision-making. Another possible explanation for resistance to settlement may be due to some coercive behavior by mediators. Again, I'm relying on empirical studies of mediators in the magistrate's court, which show that they push so strongly for compromise that parties simply resist. In addition, there are some scholars who are concerned that the lack of transparency and power imbalance is harmful to women, who are often coaxed into agreements that do not support their interests. Another reason could be disregard of customary law principles. A study of mediation offered by the Commission on Human Rights and Administrative Justice showed that mediators did not rely on customary or legal principles, but they focused on reaching compromise agreements that were often based on monetary amounts. In some cases, the focus on compromise would override the legal and customary rights of the parties. Some scholars believe that the mediator's emphasis on compromise and agreement may have pressured vulnerable parties to accept settlements that were not in their best interest. So what can we learn from Ghana's experience? My question, what is the way forward for access to justice? Certainly, providing authentic access to justice remains a challenge in Ghana, as it does everywhere, particularly with the poor and vulnerable individuals, some of whom can't even access roads to get to the courts. Ghana's civil justice system has been plagued with problems from delays to expense, and in some cases, denying parties their day in court. Studies show that modern ADR has provided speedier and less expensive justice than that available with a trial in court. But it has failed to have any meaningful influence on the backlog of cases in the formal court system. Why is this? Because litigants often resist settlement when they're participating in court-referred compulsory mediation programs. I think the same is true here. And why the resistance? Well, again, perhaps we need more empirical research, but one thing does seem clear to me, that mediators cannot ignore customary law values. Policymakers must take into account customary law and local values when they reintroduced ADR processes into the formal legal system. Chiefs, queen mothers, and elders are a vital source of knowledge about those values, and they should be consulted. By way of conclusion, I would like to end with a quote from Professor Raymond Atuga of the University of Ghana, who said very recently this year, and this is his quote, "For many communities in Ghana, chiefs and elders are still the final authority for civil disputes. Modernization should not look to substitute those alternative systems of community justice. Instead, it should find ways of encouraging them and making the most of the sense of obligation that some communities feel towards their chiefs and elders." The end of his quote. Well, I think, for me, there is much wisdom in these words. Ghana is off to a good start in practicing the wisdom of these remarks. With the passage of the ADR law of 2010, Ghana has taken the values of customary justice, with its focus on amicable settlement, compromise, and reconciliation, and acknowledge their validity along with modern dispute resolution methods, whether we want to call it hybridity or blending or infusion, they're acknowledging how valid they are. It has done this with the goal of helping parties to live in harmony and peace with each other. And for me, this is the way forward for access to justice in Ghana. Thank you.